Hello, dear friends. Today we are dealing with a very crucial subject, that is the filing of false FIR against any person, and particularly in the context of Section 69 of newly enacted Act Bharatiya Nyaya Sanhita. Section 69 of Bharatiya Nyaya Sanhita says that if a person come into a sexual intercourse by obtaining the consent with fraud, such as on the pretext of marriage, somebody entered into physical relationship, and if after that person denies the marriage, a lady has right to file a case in under section 69 of IPC, in which punishment is minimum 10-year imprisonment. In common course, what we, the citizen of India, think that it is not possible that someone is going to lodge a false FIR. Definitely, police is not going to register the false FIR. But what the situation is, firstly, we have to understand that in a criminal law jurisprudence, offenses are categorized in several categories, and the category which is most prominent for our discussion is that category in which offenses, for the commission of particular offenses, the punishment prescribed in the statute, that is Bharatiya Nyaya Sanhita, is above 7 years. Because when there is allegation in form of the information which discloses the commission of cognizable offense, and that cognizable offense, if any person indulge in that committing of that cognizable offense is punishable, made punishable by the statute be above 7 years, then police has to arrest that person immediately without any warrant. But if the allegation which discloses the commission of cognizable offense for which the maximum imprisonment prescribed in the statute is less than 7 years, then police has to comply with the guidelines of giving notice under section 41A of CRPC, that the person should come and appear before the investigating officer, record his statement, take participate in the investigation, and police not at first sight try to arrest the accused, but where offenses which is of heinous category, for which the punishment prescribed in the statute is above 7 years, then there is a direct threat to personal liberty. So, how much easy when when if a lady on whom a sole testimony a person can be convicted, if a lady come forward with allegation that look, this man said that he will marry her, but and therefore she indulged into the sexual intercourse with him, but today he is not ready to marry with him. Only this statement reveals the prima facie commission of cognizable offense as per the new statute under section 69 Bharatiya Nyaya Sanhita. And the police is a duty bound to note down, register the information in the prescribed format, that is the first information report. Because when it is a duty of police, when there is a information received to him, and if that information discloses the commission of cognizable offense, without go into the merit of the case, without any preliminary inquiry, they has to register this case and as case reveals that this offense is punishable is with more than 7 years, therefore police is duty bound to search that person and arrest him, because there is a possibility uh, he will tamper the evidence, he will threaten the witnesses, maybe he try to pressurize the informant also, because it is a very heinous offense. But when we see that when a relationship not becomes successful, at that time a lady has his hand very high, and he may file a online complaint to the administration that that person, on the pretext of marriage, I come into the relationship with him, but today he denied. Or suppose that there is want of promotion in a particular office of the government, and a lady who is not got selected for the promotion in the final list, she may easily can say that, look, he asked for some type of this type of favor in a form of sexual intercourse, and even though he does so, he didn't promoted her. In this scenario, the person against whom these allegations are made only orally without any evidence, because collection of evidence, process of collecting the evidence is started after registration of FIR. And when FIR is registered, police, without going to collect any other evidence, firstly he has to arrest that person, and therefore there is a direct threat of personal liberty. And when allegation come from the lady belongs to scheduled caste and scheduled tribe, then it become more serious, because anticipatory bail is not maintainable in this section. However, law is very settled in this respect, that yes, this is a law of the land, that if a lady is cheated or fraud, and a person getting his her consent with fraud indulge into the sexual intercourse, this is punishable by the statute. And if there is a false allegation, person has right to file anticipatory bail, but for this purpose he has to protect himself for 30-40 days. But it become more serious when a lady belongs to scheduled caste or a scheduled tribe alleges the same offense, and due to the central act, that the scheduled caste scheduled tribe act, and bar the jurisdiction of anticipatory bail, a person has become very remediless, because he has only right to bail, and the bail is going to be happened in the high court, not in the session court. Therefore we can say that he is going to be in jail for about 90 days. 60 to 90 days he has to be in jail only on the false allegation. But the scene become more worst. It become more worst when a person is in a government employee, or a person who is well known of the law. He know the nuances of the law, that mere allegation is sufficient to initiate an investigation against him, and if the offenses for which the investigation is going on come in the ambit that the punishment prescribed by the statute is above 7 years, he has direct threat, direct apprehension of arrest by the police. And even if he is frauded by his by her lady partner by his lady partner, if he try to lodge some FIR, he knows that whatever FIR he is going to lodge, that all come in the ambit of below 7 year offenses, which is punishable by maximum punishment is prescribed the 7 year, not above the 7 year. In that case, that lady is not going to arrest. And when I lost the FIR, he definitely went to the police station and trying to lodge her version, her story, and he has right in the eye of law that the law provides that anyone can lodge their information before the police station, and if the complaint, if the allegation discloses the commission of cognizable offense, police officer registered it into the register, meaning thereby even the boy lost the complaint in the present statute, whatever allegation he may raise, whether that come into, whether it would not going to come into any definition of offense, or if there is any section for that offense, then the punishment is below 7 years. Therefore there is no threat to the personal liberty to that lady. But when that lady, after knowing that that person lodged the FIR, that that lady is blackmailing her, if she went and filed the case that look, this man has come into the intercourse with me on the false promise, I means a man will be behind the bar, and therefore the RNGO Indus lacks for the larger purpose to solve the nuances and uphold the Article 14 and 21 of the Constitution of India in letter and spirit, is going to represent this nuance in the honorable courts by the way of petition. Maybe we will challenge this, the constitutionality of this provision, or we may file the public interest litigation. Public interest litigation is for the purpose for psychological treatment, social favor that a person need who is in fear that there may be a chance that he may be charged with the false case, and when there is a direct threat to his personal liberty, he is not in position to understand what is right and what is wrong. It is not possible for every person to the calculate all the risk and work accordingly to save himself. For legal support, he needs some extra money to hire an advocate, and if that person has no money, he hardly earns some money to live life, then it is a very urgent and dire situation that he has to hire an advocate to defend himself. And then for his mental pressure, for the mental tension, mental agony he is facing, for this purpose there is no clinical support at our district level hospitals. Our teenagers, person belongs to 18 to 25 years, they, most of them are cheated and fraud and cheated and defrauded by many people. It is on basis of one-to-one basis that a particular lady lodge allegation against particular person, and there is a group of people who run such racket to blackmail person. There are some fraudulent app is there, money app is there, and they blackmail people. Even they blackmailing them that they will lodge the FIR against him. In this scenario, there must be there must be some set of arrangement at every district that a person can go for a proper counseling of his mental health. And for this purpose we trying to bring some stories and share with you people to understand the nuances which causing by the section 69 Bharati Nyaya Sanhita. Thank you.